Good morning and welcome to today's estate planning webinar, which is brought to you by Lifestyle Financial Services and Domain Financial Advisors, which form part of the Lifestyle Group of companies. My name is Michelle Shembry, and before I pass over to Ravi Malhotra from Australian Executor Trustees, I'd firstly like to make sure that everyone can see today's presentation and hear us loud and clear. Okay, perfect, wonderful responses. Thank you everybody for your attendance. I'll now hand over to Ravi.
Well, thank you, Michelle, and thank you to everyone who has dialed in to listen to this morning's webinar, which is on an area of law that I certainly feel very passionately about, and that is estate planning. As Michelle said, my name is Ravi Malhotra, and I'm the Head of Business Development at Australian Executor Trustees. Over the course of the next 20 or so minutes, I hope to be able to convey some basic but fundamental concepts around wills and estate planning, and I also hope to be able to provide a few tips and tricks on what a well-drafted will and estate plan must consider. So let's get started. Now, having worked in this field of law for a good many years now, I can confidently say that there is much more to the area of wills and estate planning than what most people realise. And whilst I hope to provide a good few tips and tricks today, we will only really be scratching the surface. Should you wish to discuss your individual circumstances, I would encourage you to contact your Lifestyle Group of Companies representative who will be able to direct you to an estate planning professional who would be happy to talk specifics on your circumstances. So on today's agenda, we're going to talk through what estate planning actually is. We will look at what happens if you die without a will. We will go goodwill hunting, where I'll outline some of the dangers of the all too popular do-it-yourself kit wills. We'll talk through a small handful of some important estate planning considerations, and we'll also discuss how you can best avoid estate planning disputes and provide yourselves with estate planning certainty. So what is estate planning? Well, in its most simplest form, estate planning to me is ultimately about peace of mind. It's about taking steps to ensure that you're not leaving your loved ones with a costly and emotionally draining mess when you die or if you become incapacitated. It includes putting the right structures in place during your life to make sure your assets are distributed the way you want and in the most tax-effective and protected way possible. And whilst estate planning will almost invariably incorporate a well-drafted will, proper estate planning goes much further. Now, proper estate planning will also include, as an example, you having an enduring power of attorney and an enduring guardianship in place. That is where you appoint somebody or a combination of people who can make financial, property, medical and lifestyle decisions on your behalf if you are alive but mentally incapacitated. Proper estate planning will ensure that your superannuation death benefits and any associated life insurance flow to those who you truly want it to flow to and in the most tax advantageous way. Proper estate planning will ensure that you provide for family members with special needs without disrupting government benefits. Proper estate planning ensures that you take particular care when providing for loved ones who might be irresponsible with money or who may need future protection from creditors or the prospect of future divorce. Proper estate planning achieves all of what I've just mentioned and more in a way that ultimately minimises taxes, court costs and unnecessary legal fees. So what happens if you die without a will or an estate plan for that matter? Well, the reality is that your state, wherever that may be, New South Wales, Victoria, WA and so forth, will have a plan for you, and you might not like that plan. Studies show that nearly 50% of Australians do not have a will. I'd suggest that of the 50% that do, a proportion of those would have wills that are invalid, out of date, and perhaps not reflective of their present circumstances. At this point, I'd like to pause for a brief moment for a short poll. So it looks like we've got 70% of people who don't have a will, 20% of people who have a will but think that it needs updating, and only 10% of people who have a will and think it's up to date. Pretty interesting statistics there. So if you happen to die without a will, or if you die with a will but your will is either invalid or doesn't quite address where your assets should go, the law deems that you have died what we call intestate. When you die intestate, your assets will be distributed according to a predetermined legislative formula which sets out who gets what, and that formula may not accord with what your wishes are. Further, the process that is required to mobilise and transfer your assets is a much more time-consuming, expensive and cumbersome process than if you had a will in the first place. So let's go goodwill hunting. What are the dangers of the do-it-yourself will? As lawyers, we're often asked, why should I go and spend hundreds of dollars on a will when I can pick up a will from a post office and do it myself? Well, the reality is that lawyers make a lot more money from correcting the wrongs of poorly drafted wills than they do from doing them correctly in the first place. Some common problems that we see with do-it-yourself wills include that they're often not signed and witnessed in the appropriate manner, which renders the will to be invalid at law. Kit wills often contain ambiguous language and they'll fail to dispose of the will maker's entire estate. They often lack the flexibility to address all the circumstances of an individual because the reality is that kit wills are a one-size-fits-all type approach. Issues therefore arise when there exists, for instance, blended families, children with special needs, life interests, or anything even slightly out of the ordinary. Perhaps the worst part of will kits are that mistakes are often not realised until after the death of the will maker when it's all too late. Trying to fix problems with do-it-yourself will kits frequently involves expensive litigation, delays and massive stress for your loved ones who you leave behind. So ultimately, believe me when I say that it does pay to get your will prepared properly and professionally at the outset. We'll next look to some important considerations when crafting your estate plan, and we'll start with the topic of choosing the right executor. An executor is the person or organisation responsible for carrying out the wishes outlined in your will. When appointing an executor, you can choose a family member, a friend, or a professional trustee company such as Australian Executor Trustees. We're going to run another poll at this point, and the question for all of you at this time is, have you acted as an executor? No, it looks like based on the stats, not many of you have acted as an executor. Well, it's probably a good thing because being an executor is not for the faint-hearted. It can be a time-consuming, complex and challenging task that takes place at what can be a very difficult and an emotional time. Whilst you can appoint your loved ones as your executor, in doing so, you may in certain circumstances be leaving them with a significant emotional and administrative burden, particularly if you've got a complex asset structure or complex family circumstances. Some of the worst scenarios that I've been involved with and that I've seen is when a will maker has appointed their second spouse to act jointly together with children from a first marriage, believing that in doing so, they're maintaining harmony between both sides of the family. In actual fact, it was a recipe for disaster because it was simply an unworkable relationship between both sides of the parties. It ended up going to court, it cost the estate a considerable amount of money, and nobody ended up winning. Appointing a professional trustee company such as AET to act as your executor can have some benefits. Because of a professional trustee's capacity to act independent, objective and impartial, we're able to act on your wishes and we're not subject to family influence. This can be particularly useful in a blended family or a warring family type situation. Professional executors have got many years of experience. In fact, AET has about 130 years of experience in this space. And that sound business practice means that we're able to get the job and get the job done properly. Unlike individuals, we don't die, we don't get sick, the company continues, and we're always there to be able to take on that onerous and demanding role. Estate planning for blended families is another important consideration. Studies show that 1 in 3 marriages are in today's day and age ending in divorce. It's really no surprise then that the number of blended families in Australia is rising. Those who remarry are often keen to ensure that their new spouse is well looked after if they die. This is often accompanied by a desire to also leave assets to children from a previous marriage. In these circumstances, a well thought out strategy is required to ensure that you're able to provide for your spouse as well as your children from a previous relationship. A couple of common problems that we've seen in poorly drafted wills for blended families include the will maker leaving all assets to their surviving spouse, resulting in the children from the previous relationships missing out altogether, or the will maker leaving all or the majority of assets to the children from a previous marriage, thereby not leaving the surviving spouse with sufficient resources to continue to live comfortably. Successful blended family estate planning is a matter of sitting down with an estate planning professional, setting and communicating goals, learning about the available legal strategies, implementing those chosen strategies, and then crafting the appropriate documentation to reflect your wishes. This does require guidance from an experienced estate planning lawyer who can help to craft and implement an estate plan that provides for each spouse as well as protect the interests of their respective children. We'll next touch on estate planning when there exists vulnerable beneficiaries. Particular challenges can arise when a will maker is trying to provide for someone who is vulnerable because of, for instance, a disability, a drug or alcohol-related addiction problem, spendthrift beneficiaries or people who are financially naive, or beneficiaries who are currently in the throes of a nasty divorce or bankruptcy proceeding. There may be other reasons that cause vulnerability in beneficiaries. In these cases, a will maker has a range of strategies and options that they consider, including the use of what we call testamentary and or protective trust structures, where you appoint and implement appropriate controls to protect the needs of the vulnerable beneficiary. These strategies can have pros and cons that need to be weighed up on a case-by-case basis. A do-it-yourself kit will is simply not going to provide guidance around how you can best protect your vulnerable beneficiaries in the most practical and protective way. There's a multitude of crafty strategies that estate planning lawyers can recommend that will go a significant way to protecting your estate and your loved ones from time-consuming, costly and emotionally draining estate planning problems. If there's one takeout that I'd like to impress upon, it is that your estate planning should be personal to you, and a one-size-fits-all approach is not a smart way of going about this area. All estate plans must consider your individual circumstances, asset structure and family dynamics, and it's invaluable to seek professional advice, as this advice will invariably help preempt issues that may arise. In summary, I'd like to play a short 1.5 minute animated video that captures what we've discussed, and I'll be very happy to take any questions.
No one likes to think about death or falling ill, but it's important to plan for the future. Estate planning is simply the process of planning ahead to make sure your financial, medical, and lifestyle affairs are in place when you pass away or become sick and can no longer manage them yourself. Having an estate plan provides you and your loved ones with peace of mind that you will be looked after during your lifetime, and that your assets will be distributed the way you wish after you are gone. It is even more important if you have a complex family situation, such as a second marriage, a blended family, loved ones with special needs, or where there is history of family disputes. It is also important if you have a complex asset structure, such as holding assets in trusts. Through your estate plan, you can protect and provide for your loved ones. Make sure your assets are distributed as per your wishes and in the most tax-effective way. Nominate someone you trust to manage your financial, medical, or lifestyle affairs. Create structures such as trusts to protect your assets. And establish a charitable giving program. Estate planning can be a little tricky, especially when it comes to the legal documents which form your estate plan. So, we'll help you cover some of the basics. Your will specifies how you would like your assets managed and distributed once you are gone. Without a will, you will die intestate, and your assets will be distributed according to a strict government formula, which may not be in line with your wishes. An enduring power of attorney allows you to nominate someone you trust to make financial and property decisions on your behalf if you, for instance, have an accident, fall ill, or lose capacity. The benefit of an enduring power of attorney is that unlike an ordinary power of attorney, it will continue to operate even if you lose full legal capacity. An enduring guardianship, also known as a medical power of attorney, depending on the state you live in, allows you to appoint someone to make medical and lifestyle decisions on your behalf if you're unable to make them. Superannuation nominations allow you to nominate who will receive your super and whether it forms part of your estate. And remember, you may need to review your estate plan if your personal circumstances change. At Australian Executor Trustees, we can work with you and your advisor to tailor an estate plan to suit your individual circumstances. Don't leave it to chance. Have a plan in place and make sure your wealth is managed and distributed the way you want. For more information, speak to your advisor or call one of our estate planning lawyers on 1800 882 218.
I'm happy to take any questions. Feel free to write those questions in the box. There's a question that's just come in, and that is that 90% seems high for those who have no will or who need an update. Are those stats normal? Well, the stats in Australia are that they say that about 50% of Australians do not have a will. So yes, I agree that 90% certainly seems high. And that may be a reflection that attendees are perhaps younger, or it could be that the demographic that we're looking at the moment isn't of a mature age. So it does certainly seem high, but it certainly is an indication that there are people in the audience who need to look into their estate planning affairs and certainly get something in order. Another question has come in. What's the average cost for a will for a blended family? The answer to that is that there's a range of costs that can be applied for wills. On a simple basic will structure, it could cost anywhere between sort of $400 to $600, but it can also range up to anywhere up to $3,000 to $4,000, depending on the complexity of the individual and the protective structures that need to be put in place. Really the best way to proceed is to arrange an appointment with an estate planning solicitor. We operate on a fixed fee type basis so that you'll be well aware of exactly what you're up for before you proceed once we have a better understanding of what your circumstances are. But there is quite a range that applies when looking at how much it costs to get your will prepared. We've got another question in. What info is needed to get a will set up? So we typically have a fact find document that we're able to send to you that asks for some basic information, which really enables us to meet with you and cut straight to the chase of making recommendations once we've got a good understanding of what your circumstances may be. So I can send a copy of that fact find to you in the email that's going to follow. And if you're interested in proceeding with your will, have a go at completing that fact find document, send it back into the lifestyle representative, and we'll be happy to take it from there. There's another question in, and that is, do you recommend incorporating both a power of attorney and an enduring guardianship as part of basic estate planning? And the answer to that is absolutely. Whilst the will is often the cornerstone of any estate plan, it's really important that people also prepare an enduring power of attorney and enduring guardianship as part of that process. An enduring guardianship and an enduring power of attorney is in effect a document whereby you can appoint somebody who can make financial and property decisions on your behalf if you are alive but mentally incapacitated, and an enduring guardianship document is whereby you can appoint somebody who can make medical and lifestyle decisions on your behalf, again, if you are alive but mentally incapacitated. The will, the enduring power of attorney, the enduring guardianship, and dealing with superannuation in the appropriate way all forms part and parcel of good estate planning. There's another question. Do you also look after the New Zealand area? Do the same information and scenarios you mentioned in the slides apply to New Zealand? Best practice in estate planning entails that wherever you have assets, in whichever jurisdiction, you actually have a separate will in that jurisdiction that deals with those assets. So in Australia, each state has got its own estate planning legislation, and as is the case around the world. So if one has got assets in New Zealand, best practice would be to have a will in New Zealand as well as a will in Australia. But largely, the rules and regulations that apply are, as a general proposition, similar. There's another question in. I'm young and have no spouse or children and have a few assets. Do I still need a will? Well, the answer to that is that I'm always going to say that everyone should have a will. Many people don't realise that whilst they may not own any property, whilst they may not own any motor vehicles, if they work, they would have superannuation, and within that superannuation is inbuilt life insurance components, and that's quite often more than what people expect that they own. Superannuation may or may not form a part of your estate, and as part of the estate planning process, good estate planning ensures that your superannuation is being dealt with and flowing through to those beneficiaries who you do want it to flow to. So the answer is yes, if you're over 18 years old, it's always a good idea to have something in place. Your circumstances might not require the sophistication of others, but it is a good idea to have something in place which can always be updated as life goes on. Just having a look at any other questions that have come through. There's a question here, who do you recommend for power of attorneys or enduring guardianships in a blended family? One person, the estate planner, or the attorney? Well, the answer to that really depends on your individual circumstances. When deciding who to appoint as your enduring power of attorney, or as your attorney rather, you really want somebody who is administratively strong, who has a strong financial nous and capability, and someone who you've got the utmost of faith and trust in. It is possible for you to appoint more than one person. However, when you go beyond appointing, say, 2 people, it can become administratively cumbersome. There is an option for you to appoint a professional organisation like AET as your attorney if you were that way inclined. In terms of who you would appoint as your enduring guardianship, again, it's really a personal matter. There isn't a one-size-fits-all. You just need to look at your own individual circumstances and make the call from there. And guys, I think that's about all of the questions that have been listed out. However, we will be online for another 10 or so minutes. Feel free to, no, apparently we're another 2 or 3 minutes. Feel free to write in any additional questions that you may have, and we'll certainly endeavour to answer them in a separate email that will go out to you very shortly. Thank you for your time, and I hope you found the webinar useful. G'day again, guys. There's one final question that's come in, and that is, when is a will out of date? The answer to that is that there is no actual expiry date on a will. However, best practice is that you at least reread your will once every 3 or so years to check whether your circumstances have changed and whether there needs to be an update made to that will. A well-drafted will always take into account a range of considerations, For instance, you might appoint one executor, you'll have an alternate executor in the event that the first executor is unable or unwilling to act, and you may even have a third option after that as well. A well-drafted will doesn't take into account any particular asset, so we won't say that I give my motor vehicle registration number blah 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 to such and such person. We simply group all of the assets holistically. So unless you want to remove somebody from your beneficiary list or add somebody new as a beneficiary, there really need not be a need to constantly change your will. As I said, we do recommend that you reread your will at least once every 3 years, but there is no expiry date as such on a will. And guys, I think that does it for today. We will, as I said, endeavour to get out some further information to you and a more formal response to the questions that were asked. But in the meantime, I thank you for dialing in, and I hope that you found the session informative and hopefully enjoyable too. Thank you very much.